Welcome to the Retirement Guy Podcast with Gary Alden from the Kingwood Investment Group. In this podcast, we educate people in or near retirement so they can make informed decisions and bridge the confidence gap. Learn how to mitigate risk in retirement so you don't run out of money before you run out of you. Join Gary Alden and explore strategies on how to live a stress-free retirement.
Hello and welcome to the Retirement Guy with Gary Alden from Kingwood Investment Group. Today we're going to be talking about estate planning. Good morning, Gary. How are you?
Good morning, Eric. We are just fine.
All right. I know that you love to start me off not knowing what I'm talking about with a trivia question. Do you have one today?
Yes, I do.
Oh boy, here we go.
I thought this might be apropos because we're in football season.
Mm-hmm.
Many years ago, there were two football leagues. There was the National Football League. There was the American Football League, and they were fighting each other for our attention on TV, and they merged. So the old American Football League merged into what we call the National Football League today. But to even out the two divisions, three teams from the old National Football League left the National Football League and moved over to the American Football Conference. So the question today is, what three teams left the old NFL to join the American Football Conference so the two divisions could be equalized?
I don't even know what football teams existed back then.
I know, and I remember, and I didn't even have to look this one up.
Oh, really? Well, see,
Yeah.
You're dating yourself there a little bit, and maybe
There you go.
it's not necessarily a good thing that I'm younger than you, but because you're much wiser than I am. But yeah, I don't have a clue on this one. I'm going to have to wait to the end of the podcast, Gary.
Okay, remind me to give you the answer.
Okay, I will. All right, so we're talking estate planning today, and I don't know if we're going to fit all this in one podcast, but we're sure going to give it a shot. So where do we start today?
Well, these are kind of the basics. And before we get started, kind of a disclaimer in here, we're going to be talking about some legal issues in here. We're going to be talking about some tax issues. And we're going to be talking in generalities. Obviously, if someone is going to go out and do something, you need to talk to your tax professional.
Exactly.
Talk to your legal professional, your financial advisor, to make for sure what we're talking about today will fit your situation or not. So you always want to talk to a professional. This is general information we're giving today. So please consult a professional for your particular situation.
And those that are listening that don't have a trusted advisor in one of those categories, a CPA or an attorney or any of those things, I know that you can reach out to Gary and his team, and he has a bunch of different folks that he can actually suggest and say, hey, this is somebody that you could talk to, just because he has good relationships and connections with folks. So if you don't have somebody, go ahead and give Gary a call. He's got some suggestions for you, I'm sure.
There you go. We've got them in our own office. We have our own CPAs here, our own attorney here in the office, our own Social Security specialist, Medicare specialist. We're kind of one-stop shopping for retirement.
That's true.
Plus, I know other people in the area and also other people around the country. So if we can be a resource for you, let us know.
Fantastic. All right, let's get into this.
Well, you know, when we talk about estate planning, sometimes people think, the word estate, that's for the wealthy. Everybody's got an estate. You know, if you have a nickel in your pocket and that's all you've got, your estate is the nickel in your pocket.
Exactly.
And maybe the shirt on your back. So everybody's got an estate, and you want to protect that estate, both from the tax man and maybe from legal issues and complications you could be leaving your siblings, your kids, whoever is going to receive your estate when you pass away. So there's obviously several objectives on estate planning. While you're alive, you want to document your intentions. You know, where do you want your money to go? Who gets your favorite picture there in the den? You maybe want to appoint a person, this is while you're alive, to maybe make medical decisions for you. If you're, say, in a coma in the hospital, maybe someone to make financial decisions for you if you are unable to, maybe appoint a guardian for minor children. So there's several things while you're alive that you want to put an estate plan in place in writing, usually with an attorney, to make sure, you know, what you want done really gets done. Then after death, you want to have everything written up. So maybe, what if I passed away today and I had minor children? Well, I want to appoint a guardian for those kids.
Mm-hmm.
Or what if I have a special needs child who's an adult? Who is going to take care of that special needs child when I say pass away? You also, of course, want to distribute your assets to who you want to have to receive those assets. Maybe you want to leave charitable gifts to your church or an organization. And through all of this, bottom line, you want to minimize potential expenses and potential income taxes. And there's a way to reduce or eliminate taxes if you structure things properly.
Mm-hmm.
One of the first things that in planning for incapacity, everybody in the audience listening today, everybody needs a durable power of attorney. And all that is, it's a legal document that says, I am now appointing a person or persons to act and make financial decisions on my behalf. But one thing you have to understand is a power of attorney is only good while I'm alive. One of my clients called me a few years ago and he says, hey, Gary, I wanted to let you know my father passed away. And my client lived in another state. And the son calls me up and says, hey, my father passed away. Let's sell everything in dad's account and just put it in the cash. So it's there in cash to distribute out to the kids down the road. And I says, we can't sell anything in the account. He says, well, I'm the power of attorney. I said, you were the power of attorney until your father passed away.
Oh, no.
So all the investments have to stay as is until the will gets probated or the trust goes in, or, you know, whatever legal document is put into place to liquidate that account.
Wow.
The other thing that you should have, Eric, is it's called a healthcare proxy. Some people call it an advanced healthcare decision. Other attorneys might call it a medical power of attorney. So healthcare proxy, advanced healthcare directive, or medical power of attorney, they're all basically the same thing, just different verbiage. And again, it's a document that appoints a person to make healthcare decisions for you if you're unable to do so. So let's just say you were in a coma in the hospital and your wife was, say, your healthcare proxy, or your brother, your sister, your cousin Fred, whoever, they could make medical decisions for you with that written document. So very, very important to have.
Got it.
The other thing you want to have is a living will when you plan for incapacity. All a living will is, it documents your wishes about being kept alive in case of a terminal illness. In other words, if you say, hey, I don't want to be a vegetable and I don't want to be a burden to my family, I'll give somebody authorization to pull the plug.
Yeah.
And it's kind of I went through that with my own mom, and that's a huge burden when all of a sudden the doctor sits there and tells you or asks you, hey, Gary, should we pull the plug on your mother?
Yeah. Wow.
And you get asked that once, hopefully not more than once in your entire life, and the world just comes down on you at that point. But wasn't really my decision. It was mine and my two sisters. And luckily for us, my mother recovered and we didn't have to make that decision.
Wow. Awesome.
So that was kind of nice. The other thing, and you may carry one of these in your pocket, Eric, do you by any chance carry a anatomical gift form in your wallet?
I misplaced mine, Gary.
Well, I carry one in my wallet. Basically what it says, hey, if I die and if you want my parts, if you want my lungs or my liver or my left finger or whatever, they can go to medical research, or, hey, maybe if there's somebody waiting on a kidney transplant, my kidney works, hey, you can have my kidney.
Okay, now wait a second.
So,
you said an anatomical gift form. Is that the same thing as my driver's license saying I'm a donor?
Yeah, I think so. I think it's the same thing.
Okay, well then, yes, I do. All right.
Yeah, there you go. Some states do that and incorporate it into one little piece of paper.
Gotcha. All right. Hey, Gary, can we go back for a minute?
Sure.
I just want to point out something or talk about something. You had said, overall, looking at estate planning, you had talked about what happens upon death as far as your children, your assets, and so on and so forth. And I would think that would be a will, right? But it sounds like there's other documents besides just the will that you need to make sure that those different things are happening. What's not covered in a will?
Well, there's a lot of stuff not covered in will. We'll actually get to trust in a second, but
okay.
Your will can be very dynamic depending on your attorney who does your will. But everybody listening should have a will. even if you just get out a piece of paper and write out your intentions on a piece of paper, have it witnessed by maybe a couple of people that are not named in the will, at least you've got that's called a holographic will. At least you have something in place, maybe you can get to a legal professional and have one done so you know it's done right.
Yeah.
There's some places on the internet like LegalZoom and so forth where you can do it yourself. I thought it was important. I wanted to make sure all my T's were crossed, my I's were dotted. So I paid an attorney. It cost me more money than LegalZoom, but it also gives me the peace of mind knowing that I've got everything set in place legally. So if I pass away or my wife passes away, that we've got all of our ducks in a row.
Got it. Okay. Thanks.
So, but again, the 4 documents that most people need in most states, you have your will, you have your living will, you have your durable power of attorney, and again, you have your healthcare power of attorney or healthcare proxy.
Got it.
And for a lot of families, those 4 documents, and again, if you had a couple, I need those 4 documents. My wife needs those 4 documents. That's going to cover most situations. But we'll talk about here at the end of the day, we'll talk about maybe a couple of different trusts that might want to be considered that maybe cover some more areas for you.
Got it. All right.
And of course, one of the things when you do estate planning, you want to minimize estate taxes as much as possible. And there's some strategies to go in and do that. And one of the strategies that you might want to do, it's called capital gains taxes. So let's just say I have some IBM stock. So I've got some IBM stock. And let's say I wanted to give 100 shares of IBM stock to one of my kids as a gift while I'm alive, so they can have that asset now. Well, they inherit my cost basis. So let's just say, for purposes of example, I paid $1 a share for IBM, but it's worth $100 a share when I give it to my son or daughter or whoever. So let's say I give my son 100 shares of IBM. The cost basis is $1. If he sells that IBM stock, he owes capital gains on the $99 gain. So again, cost basis of $1, you sell it for $100, he would owe taxes on the $99. However, if I left him that same 100 shares of IBM in my will, he gets what's called a step up in basis. So if IBM is worth $100 a share the day I die, and my son inherits that 100 shares, and he sells it for the same $100, there is 0 capital gains taxes.
So that you can't pass it to them while you're living. It has to be after you pass.
Well, no, I can give it to him while I'm alive, but he inherits my cost basis.
I should have clarified. Yes. If you want them not to be nailed with those taxes, you have to wait and put it in your will.
Yes, and they get a step up in basis.
Got it.
And that's under current tax law. They have done away, when I say they, the IRS has done away in history of the United States. They've done away with cost basis, I know, at least 2 times, and it's created a huge mess because nobody can find cost basis. By the way, we're talking about a stock here. It could be a piece of land. What if I bought a piece of land and I paid $10,000 for it, but it's worth $1 million now? Again, my son would owe capital gains on the difference between the $10,000 of cost basis and whatever he sells the land for. However, if I leave him that same piece of land when I pass away, gets it appraised for date of death. If it's appraised at $1 million and he sells it for $1 million, 0 capital gains on that land.
And is that something that's triggered automatically if you put it into a will? Just speaking of the property, will somebody estimate or evaluate that property automatically because it's in the will? Does the attorney do that or hire somebody to do that for your son? Or do they have to know, I have to get this evaluated right away?
Yeah, you're going to have to go out and get a professional appraisal. One attorney I dealt with years ago, what he liked to do, and this was his opinion, he went out and, because it was an extremely valuable piece of property, he got 3 different appraisals. And he used, if you will, the most conservative appraisal when they were doing the tax return.
Why would he do that?
Try to minimize taxes.
But if he's using the minimum, wouldn't that, if they get it appraised the next year and the next appraisal is much higher so they can sell it at that, wouldn't that increase their taxes?
Well, then you're going to have to get a new appraisal.
Got it. Okay.
We're just talking about a date of death. you're trying to get an appraisal, as soon as possible.
Yes. Yep.
Get with somebody who can appraise real estate and certified to appraise real estate to appraise that as soon as possible after death.
Got it. All right.
On a piece of land or, property.
Mm-hmm.
Stocks is real easy because you can find out what the stock was worth on date of death.
Yeah.
The next thing we want to cover, Eric, is gift and estate tax exclusions. Currently, if I wanted to say give you a gift for $15,000, and by the way, Eric, I'm not giving you a gift for $15,000.
Oh, come on, Gary.
But if I wanted to give you or each one of my children or anyone up to $15,000, there is no gift tax on that $15,000.
Okay.
So I could give $15,000 to each one of my kids. My wife could give $15,000 to each one of our kids, and there's no taxable event. However, if we want to give more than the $15,000 to one of our kids or any person out there, there is maybe, keyword here is maybe, gift tax due. And Eric, do you know if there is gift tax due, who pays the gift tax? Is it the giver or the receiver?
Well, I would think that the receiver would pay it.
No, it's actually the giver pays it.
Really? Well, that's good. I guess.
So if I wrote you a check for $1 million, which again, Eric, I'm not giving you a check for $1 million.
All right.
And if I gave you a check for $1 million, it'd just bounce. But if I did give you a check for $1 million, and if there were any estate or gift taxes due on that money, I would have to pay them. You'd get all that money to spend free and clear.
Well, I guess that's a good thing, because if you're given the gift, you don't want part of that gift taken away.
There you go. So right now, and by the way, this is indexed. It has a inflation index, and it goes up in $1,000 increments. But currently, the gift tax exclusion is $15,000. So again, I can give $15,000 to each one of our children. My wife can give $15,000 to each one of our kids. So each kid could give $30,000 every single year,
Mm-hmm.
and there's no gift taxes due. Now, every single person in the United States also has it's kind of a new concept that you have a lifetime gift tax exclusion, and it's about $5.5 million per person. And you can either use it while you're alive or you can use it at death. So let's say while I'm alive, I want to give you $15,000, there's no taxes, gift taxes due. But let's say I want to give $50,000. I could either pay the gift taxes on the $35,000 excess, or I could use up part of my lifetime gift tax exclusion now instead of waiting at death. It's kind of a neat feature.
Yeah. I mean, so you're saying that you could give $100,000, and just as long as you're saying this is going to be part of that $5.5 million or whatever that number is, then there's no tax on it.
Correct.
Oh, okay. Well, that's great.
And I've got that roughly $5.5 million. My wife, Linda, has $5.5 million. So let's say while I'm alive, I never use up any of my $5.5 million. When I pass away, my $5.5 million exclusion is now portable to my wife.
Oh.
She now has $11 million, over $11 million gift tax exclusion. So let's just say, fast forward, I pass away next week. My wife, Linda, lives another 30 years. And by the time she passes away, our estate is worth $11 million. And if the estate tax exclusion is still there, like it is today at $11 million, there would be not one penny of estate taxes due to our kids.
Okay. And so that's total for the giver, not per person they give to.
Well, no, anything we gave away up to $11 million, nobody's paying any gift taxes. So
okay, so it's per giver then. Yeah,
nobody's paying any gift taxes.
Yeah, so it's per giver. So it's upon you. It's not like you could get $5.5 million to each one of your kids.
Oh, no, it's total.
It's total. Yeah, total for each giver. Got it. Okay.
Right. Everybody should have a will. The old saying in Monopoly, don't pass go, don't collect $200. It's the same way. Everybody listening, you need a will. You do not want to die without a will. All you're doing is creating a big mess for your family. Mm-hmm. Who's ever inheriting the money. And it's kind of like pay me now or pay me later. You've heard that phrase. Either pay an attorney now to do it or pay an attorney after you're dead, somebody's going to pay it. And it's a lot more expensive for the attorney normally to clean up the mess after you die versus doing it while you're alive, nice and simple. I know my attorney made it extremely simple for Linda and I. We sat down with her in one meeting and did some planning. Then the attorney worked everything up. We came back in, everything looked good. We got it notarized, witnessed, and everything is good. And that's now in a safety deposit box and another copy in our safe at our home.
I heard a long time ago, Gary, that dying with a will is like an attorney taking the Ming vase off the mantle and passing it to your children. If you die without a will, the vase hits the floor first. The attorney has to glue it all back together and then hand it over.
And it's probably not going to look real good either with all those cracks.
Exactly.
Well, I like that. I like that analogy. So, if you die without a will, again, I always use the analogy, hey, you die without a will, you're going to be putting the attorney's kids through college because he's going to charge you more money, again, to fix the mess. So again, when you die without a will, all your kids are going to be treated equally. Maybe that's what you wanted, but maybe you had one child who I've got that exact situation now. Right now, one of my clients lives with one of their children, and in her will, she wants that child to have more of her estate because this child helped her out more in life. She's not disinheriting the other kids, but she says, hey, I want Susie, my daughter, who took care of me these last 10 or 15 years of my life, lived with her. She should get a little bit more of my estate because she went the extra mile.
Absolutely. Yep.
So, or maybe you have a child you don't want to leave any money to because maybe they have a drug issue. I've seen that happen online. And then maybe sometimes just one of your kids upset you and you cut them out of the will. So you want to document your intentions with that legal document. And again, when you pass away, in most states, the judge who probates your situation, usually their hands are tied and they have a formula they have to follow. And maybe a distant relative, your cousin Fred that you hated, maybe ends up with all your assets when you die. And that's not what you intended. Now, again, we talked about this a few minutes ago. Sometimes a will may not be enough. You may need extra documents, and that sometimes is when maybe some type of a trust comes into play. One of the most common things is a living trust, and a living trust is a will substitute. And the trust, it doesn't save you in itself. It will not save you one single penny in, say, estate taxes, but what it does, it avoids probate. It also is totally private. So in most states, when you pass away with a will, that will is now a public document and anybody can get hold of it. And there are some scavengers, some bad people that look in the newspaper and they see when somebody dies and they wait a few months, the will's probated, they go get down a copy and then they prey on, say, the person who inherited the money. So I passed away and they now start preying on my 85-year-old wife who may not know what's going on. And there's a lot of bad people in this world.
Absolutely.
So a living trust is never probated and it's totally private. That's why I have a lot of clients that have a living trust, not because they have lots and lots of money, but they want their legal affairs totally private. They don't want them public. And if you probate a will, it is a public document and virtually anybody can get a hold of it. In fact, you can go on the internet right now and look at Princess Diana's will because it is a public document and you can see how much money her estate was worth, who she left money to and all that. It's just a public document.
Yeah.
Eric, would you like to get your estate size lowered while you're alive?
I'd rather not.
Well, one way of lowering your estate while you're alive is you could give me your house or car.
I could, but you're not writing me a check for $100. So no, Gary, I'm not giving you my house or my car.
Well, that's one way of getting your estate down is gifting while you're alive, is because it will reduce the size of your estate. Because if I have, say, $1 million worth of stock today, and I give away $100,000 today, when I pass away, my estate's only got $900,000.
Got it.
Worth
Yes.
of stock. So sometimes people do give away stuff while they're alive. Sometimes because they just want to help out the kids while they're alive, and they don't want to. They do not want the kids having to wait, 30 years until they pass away.
So there's advantages to reducing the size of your estate, is what you're telling me.
There you go.
All right.
Now, there are several things that can do direct transfer that you don't have to worry about a will. one of the things, if you have a life insurance policy, an annuity contract, those are a couple of things that you name beneficiaries. The same thing if you have an IRA account, a Roth IRA account, a 401k plan, you always have to name a beneficiary. So whoever you name on those forms, it avoids probate and goes right to the person you want to have the money. But make sure, Eric, that you have your beneficiaries up to date.
Mm-hmm.
Because if on your beneficiary form you have your ex-wife listed, but in your will you say you want your new current wife to get your money, the will be second to your beneficiary form. So in other words, your beneficiary form supersedes whatever your will says. So if my will says all my money goes to my current wife, Susie, but my life insurance policy says it goes to my ex-wife, Mary, Mary's going to get the money.
Got it. That might not be a good
your
situation.
Current wife is not going to be real happy if you didn't keep your beneficiary forms up to date.
Exactly.
So at least every year, every other year, you should sit down with yourself, your spouse, make sure all your beneficiaries are still up to date, and never put one of your beneficiaries as your quote estate. Always name a person, an entity. Like I want 10% of my estate to go to United Methodist Church of Kingwood, Texas, and document that also with that church's tax ID number to make for sure there's no, no misconstruing what your intentions are. So a living trust is something now to save money, and this is going to be the last thing we cover today. There's a neat little thing out there, and again, need to get with an attorney if you decide you want to do this. It's called a charitable remainder trust. It's called a CRT. We were talking about that earlier, CRATs and CRUTs and CRTs and things. But a charitable remainder trust can be used to provide a gift to a qualifying charity of your choice, and then generates a source of income for you while you're alive and gives you an immediate tax deduction on your tax return. So here's an example of a gentleman who I saw do this. He owned a lot of stock in a company called Exxon, large energy company. And he had this stock outside of his IRA account. So he had a lot of capital gains. So if he sold that Exxon stock, could create a big taxable event for him. So what he did, he got with an attorney, set up a charitable remainder trust. The stock was then placed inside the trust. They sold the stock, and since it was inside the charitable remainder trust, there was no capital gains taxes on the sale of the stock. Then he bought inside the charitable remainder trust, bought an annuity that would pay him lifetime income for as long as he lived. And then at the end of his life, it would give a charity whatever is left in the trust at his death. So that's why it's called a charitable remainder trust. Whatever is remaining when you pass away goes to your favorite qualifying charity. It does have to be a real charity, something you didn't make up. So if you're leaving money to the Red Cross, the Boy Scouts, Ronald McDonald House, whoever, it must be to a legitimate charity. So you get a nice big tax deduction up front. You don't have to pay taxes on those gains. So you can put all 100% of the money to use, say, in an annuity or whatever else you and your attorney and financial advisor decide, and provide you lifetime income. And then what's left at the end of the day goes to your favorite charity.
That's a great
so
option.
Everybody's happy. The charity's happy.
Yeah.
You're happy. You don't have to pay taxes. You got some guaranteed lifetime income. Life is good.
That's great.
So it's just one of the things you can do. And there's literally dozens of different types of trusts that can be done in different situations, again, to save you money on taxes and give more money to the people that you love.
Gary, I would love to do a podcast just on trusts and give some examples of how these different trusts are used by different families in different situations. Could we do that at some point?
Yeah, we sure could. And there's a couple of board certified estate planning attorneys here in the area that I'm sure I could get one of them to come over here, and we could have a very, very nice discussion.
Awesome. All right. We need to wrap it up today, but I still need to hear the answer to that trivia question.
Oh, the three teams that left the old National Football League and went to the American Football Conference.
Yep.
It's pretty simple. The Pittsburgh Steelers.
Okay.
The Baltimore Colts. and the Cleveland Browns.
Baltimore Colts, who are the Colts
Which moved
now?
to Indianapolis.
Yeah,
That's where they are now.
That's right.
But they were the old Baltimore Colts, the Pittsburgh Steelers, and the Cleveland Browns left the old NFL, went to the AFC, the AFL, which became the American Football Conference, and that evened out the two divisions.
All right. And we have the NFL today because of it.
There you go.
Good deal. All right. Well, Gary, thank you so much for your time today. I'm looking forward to the next podcast.
I am too.
All right. And thank you all for listening to the Retirement Guy podcast with Gary Alden. If you have not subscribed to the podcast yet, please click the subscribe now button below. This way, when Gary comes out with a new podcast, it'll show up directly on your listening device. This will make it much easier to share these podcasts with your friends and family. Again, thanks for listening today. For everyone at Kingwood Investment Group, this is Eric Johnson reminding you to live your best day every day. And we'll see you next time.
Thank you for listening to the Retirement Guy podcast. Click the subscription button below to be notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of Kingwood Investment Group. The content has been made available for information and education purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions that you may have regarding your investment planning. Kingwood Investment Group is independent of Next Financial Group, Inc. Securities and investment advisory services offered through Next Financial Group, Inc., member FINRA/SIPC.